as we give kind of, again, an overview of how those pertain to you in your employment. So the first employment law that I want to touch on is the Americans with Disabilities Act. And so this is a law that prohibits employers from discriminating against individuals who have disabilities. That's essentially it. And that is based on hiring decisions, terminations, promotions, training opportunities, and any privileges of employment. And so a lot of these laws are federal laws, and they have several rules around them. But one of the things about the Americans with Disabilities Act is it pertains to employers who have 15 or more employees. So that's just something to keep in mind. If you have a small group, not every single one of these laws may pertain to you. But of course, it's always a best practice to kind of try to stay consistent with them and consistent with any of your employment decisions. So with the Americans with Disabilities Act, an employer is required to make a reasonable accommodation if they have a known disability of a qualified applicant or an employee, as long as it wouldn't pose an undue hardship on the operation of the employer's business. So some examples, you may have an applicant who's going through an interview and they're hearing impaired, and they may need a sign language interpreter to do the job interview. And so when you're making the determination on whether or not that's a reasonable accommodation, you're going to look at something like, are you able to get a sign language interpreter? What is the cost? You would be pretty hard pressed to say that you could not afford that accommodation unless it is extremely expensive, which a sign language interpreter for an hour or so probably wouldn't be. So you really need to have a process in place by which you go through this process, and you have documentation that you would require an individual to submit. You would have designated individuals that would determine if this is an undue hardship. So it's definitely recommended that you have a process in place as you comply with this law. Another example may be an employee with diabetes may need regularly scheduled breaks so that they can step away and have some food or monitor their blood sugar, or an employee with cancer may need time off to attend any sort of radiation or chemotherapy appointments. So these are just some examples of things that employees or applicants could request. And then you may or may not be able to accommodate those as an employer. But again, these are all pretty reasonable. So it would be very difficult for you to say that you could not accommodate these specific types of requests. And so the Americans with Disabilities Act kind of goes hand in hand with the Family Medical Leave Act. So the Family Medical Leave Act provides certain employees up to 12 weeks of unpaid leave per year for their own serious medical condition or the serious medical condition of a qualified family member. And that's a parent, a spouse, or a child. And there are other provisions to the leave where they have to care for a qualified service member, but that's a separate piece of this leave. And so this, again, is a federal law, and it pertains to the employers that have 50 or more employees within a 75-mile radius. And so, again, that may not be all of you on this call. If you do not have to comply with FMLA, then you would not have to provide this type of leave to your employees. But you're going to want to look at the Americans with Disabilities Act, because maybe someone needs to be out for the birth of a child. That's considered a short-term disability because they gave birth. And so you would treat that like any other short-term disability. So you may provide leave as an accommodation under ADA, even if FMLA does not apply to you. So just some things to consider when you're looking at your policies. And you may say, well, I don't have 50 employees, but I would like to provide the same leave that FMLA provides to be consistent. That's, again, something that you could do as well. So in order to qualify for family medical leave, an employee must work for the employer at least 12 months. And within that 12 months, the past 12 months, they must have worked 1,250 hours. And that's work hours, not things like holidays or paid time off. Those are working hours. So you would need to have a process in place by which you assess how many hours that employee has worked in the past 12 months. And then when I say they've worked for the employer for at least 12 months, you have to look back within the past 7 years. So maybe they worked for 6 months, 3 years ago, they left and came back, and they've worked for 7 months. So they have 13 months of service. Then you would just need to look back at the last 12 months to see if they've worked 1,250 hours. So like I said, there's lots of different components to this law. It will not apply to everyone on the call because you should have 50 or more employees, but just some things to note if you do use this leave. And then they are also required to provide you with documentation from their medical provider stating the amount of leave that they need, that they cannot work, how much time they need off, whether that's on a continuous basis. So they have a surgery and they need 3 weeks for recovery, or maybe on an intermittent basis, which may be I need every Wednesday off because I have to go for chemotherapy or something like that. So they would need to provide documentation from their medical provider within a certain amount of time. If you are required to comply with this leave, I definitely recommend that you review the documentation as it relates to this leave from the Department of Labor, because there are specific forms that you have to give the employee. There are specific forms you give them that their medical provider completes with detailed information. There's information that you have to give back to the employee saying you're eligible for FMLA. You will be using 6 weeks of leave. Therefore, after this 6 weeks, you will have 6 weeks of FMLA available to you in the next 12 months. So again, if you are required to comply with this law, definitely recommend looking up those forms and making sure that you're using those. You also have set timeframes during which you have to reply to the employee. If they request to leave, you have to give them their documentation within 5 days. If you receive the paperwork back from the provider, it has to be within a certain time frame. So again, this is a pretty detailed law. So if you don't have to comply with it, you can definitely provide leave to your employees and decide for your organization what would be the best way to provide leave for your employees. But when it comes to FMLA, they have very specific processes that you have to follow. The next law is the Health Information Portability and Accountability Act, or Hipaa, and this relates to protected health information of employees. So you may come into contact with health information as it relates to your benefit plans. If you have a benefits administrator who handles the enrollment forms and things of that nature, that medical information is considered protected. If you receive those FMLA forms from an employee saying they need leave, it could have medical information on it in terms of what their diagnosis is. You have to treat this as protected health information. So any health-related documentation that you have should be kept separate from your employee files in a locked file cabinet. So a best practice is to have your employee files all together. That could be things like the employee's W-4 or W-2s, any employee application information, and then any health related documentation should be in a separate employee file, and again, locked up at all times. It's best to designate one person that maybe can go through some Hipaa training, and then they are responsible for those documents just to make sure that they are complying and keeping those secure. And then, of course, anything medical or health related should only be shared on a need to know basis, because we are the church and we do so much outreach and ministry. Sometimes it's tempting to say, oh, well, I know that Joe has cancer, so let's all pray for Joe. Let's let everyone know so that we can all get together and send flowers and be supportive. But when it comes to your role within the organization, if it's related to receiving this information, you really cannot share it with individuals outside of those with the need to know. In terms of deciding accommodations and providing leave, you really shouldn't be sharing that information. Now, Joe tells everyone that's on Joe. But in terms of your role or whoever's role is responsible for these HR duties, they cannot share that information. It is considered protected. And another thing I just want to note, it's important to also train your managers so that they know if an employee comes to them and says, you know, I have cancer, I'm going to be requesting leave. I just want you to know that they also know they don't need to be sharing that information outside of maybe to the person who would be providing the documentation. It's just a best practice, though, that your managers know exactly what to do when someone comes to them. The next employment law is Title VII of the Civil Rights Act. And so this is the law that protects employees or it prohibits employers from discriminating against employees on the basis of 5 things: race, color, sex, national origin, and religion. And this pertains to all aspects of employment, and it prohibits harassment in the workplace as it relates to these 5 things. So you may think, okay, well, we have race, we have national origin, colors, and there are 2. Individuals can be of the same race or national origin, but have different color skin, so that's protected as well. So you just need to know that these things, this is the law that protects individuals against this type of discrimination and harassment. And that can include anything like stray comments, not just straightforward things like racial slurs or things that are obviously prohibited, but any sort of stray comments or anything that the employee perceives as could be harassment or discriminatory against them based on these 5 things. And we're going to touch on harassment later on and specific examples of that and things that are prohibited. But one thing I want to note here is that religion is listed. We are a religious organization. So you can say, based on the job that I have open, I need someone who is United Methodist. And then you can say, are you a member of the United Methodist Church? Are you a member of, are you an ordained minister in the United Methodist Church? Those are reasonable. You can't use that religion exemption in any other components and ask them things about their personal life or things about other things that are going on and say it's part of that religious exemption. It only pertains to, we need someone who's a member of this faith in this role, because this role, in this role, it is relevant. So if you have a janitor opening, you may or may not be able to say if this individual needs to be a United Methodist. More than likely, you probably can't justify that individual needs to be United Methodist. But if you have someone who is, working on writing sermons or doing some sort of ministry, then that would be a position in which you could make that a requirement of the position. And so another protected class under a different law is the Age Discrimination in Employment Act and the ADEA. And so this pertains to employers with 20 or more employees. And it prohibits employers from discriminating against employees who are older, and there is a cutoff. It's 40 or older. So if you're below 40, there's no age protection essentially in employment decisions. If you're 40 or older, then it is a protected class. And it's not categorical. If you hire someone who is 56 over someone who is 70, you can't say, well, I hired someone over 40, so it's fine. That individual who is 70, if they feel like they were discriminated against, could go and file a charge against the fact that you hired someone much lower than them who may not be as qualified. So just keep in mind, it protects individuals who are 40 and older from any sort of age-related discrimination. And so that means when you are doing interviews, you shouldn't ask any questions that relate to how old an individual is. You shouldn't ask what year they graduated high school, if they intend to retire soon, things like that. So just keep that in mind as you're going through your employment decisions. If you're going to promote someone, you shouldn't say things like, well, they may retire in 2 years. I want someone who's going to stay in this role longer. That is prohibited activity. And then the Equal Pay Act, this requires that men and women be paid the same amount if they have the same knowledge, skills, and abilities. So equal pay for equal work. And some things to consider with that, when you look at the pay for the individuals within your organization, what you want to do is look at someone who's in the same job, if they are male or female or of different races, things like that. Are they paid equitably? Are they paid, is the individual who's been there 5 years paid more than the individual who just started? That's perfectly fine, because that is an objective reason for someone to make more than another individual. But if you have individuals who have the same knowledge, skills, and abilities, same tenure, but the male is paid $10,000 more than the female, you're going to want to evaluate that and consider your pay practices. So just some things to consider as you go through reviewing your practices for the things that you have in place. And the next law that we're going to discuss is the Fair Labor Standards Act. And so this is the law, I think, that comes up the most in the questions that we get in the practices of different organizations. Because we are a church organization, sometimes individuals think that these types of laws don't pertain to their organization, but they definitely do. And this is one of the most costly laws that if you are violating them or not following their rules, you can definitely get into some costly fines or back pay for employees. So the Fair Labor Standards Act makes sure that you fairly compensate employees. And there are a couple of different components to this. It sets a minimum wage that you must pay employees in terms of an hourly basis if they are an hourly staff member. If they're an hourly staff member, they have to make at least $7.25 per hour. And that's been since July 2009. It has not changed on a federal basis since then. If you are in a state that has a state minimum wage, then you have to pay the higher of the two. So you can't say, I'm going to pay federal and ignore the state. If the state is higher than the federal, you have to pay the state minimum wage. And it ensures that employers compensate non-exempt employees properly for overtime. So you're going to look at your employees in terms of, are they exempt from overtime or non-exempt? If they are non-exempt, you have to pay them correctly in terms of how you pay overtime. And we're going to go a little deeper into this law and talk about it again in more detail. So again, this law sets the minimum wage. And it looks at overtime pay. It determines your record keeping processes, and it determines youth employment and how you pay individuals, how old they have to be to work and things like that. The Fair Labor Standards Act does not regulate vacation pay, sick pay, or holiday pay. It is up to employers if they want to provide that paid time off for employees. There are some states that require these types of pay, but in terms of the federal law, it does not determine that for employees. And then for break times, again, this is not on a federal basis, it's on a state basis. So some states don't require breaks for employees that are hourly. In Tennessee, if an hourly employee works at least 6 hours, you have to give them a 30-minute unpaid lunch break. Each state is different, so you want to check into that if you do have hourly staff members. And then again, the employers determine whether or not they want to offer these benefits, but of course, offer them on a consistent basis, even if you're not required to. If you do decide to offer them, make sure they are offered consistently. And so this law divides employees into two different categories. Non-exempt staff members are hourly. They clock in and out. They're paid on an hourly basis. And they are protected under this law in that they are given overtime. So if they work more than 40 hours in a work week, they get time and a half for any hours worked over 40 hours in a work week. Exempt staff members, those are employees who are paid on a salaried basis. So they are paid at least $684 per week to be exempt from the Fair Labor Standards Act. So there are two different components to whether or not someone's exempt. You look at the job duties that they have and the responsibilities that they have in terms of their job. And then you also look at how much they're paid. If they are not paid at least $684 per week, which works out to about $35,500, around that. If they are not paid that much, you cannot make them salaried because they don't meet that piece of the test. You cannot say someone's salaried and then pay them less than that amount. So that's another thing to evaluate when you go back and look at your pay practices. You have to meet that threshold before you even have the conversation about whether or not their job would be considered exempt in terms of the duties that they have. So when it comes to hourly staff members, they have to be paid for all time worked. All compensable time must be recorded and paid to them. And work is considered any time that they give to their employer, even if they are not exerting any like physical or mental requirements. So let's say I have a individual who answers the phone. She's a receptionist. She sits at the front desk. And because of COVID, maybe you have her come in, but no one's coming in. No guests are coming in. She's just answering the phone. So she may sit there for an hour with nothing to do. You're still requiring her to give you her time. She's required to come in and sit at that office. So you have to pay her, even though she's not doing any work during that time. So it's just an example. If they are required to give you their time, then you have to pay them for it. And this includes any time when employees take work home. It's good to have a policy in place that makes sure employees are aware of their responsibilities, that if they are working, even if they're at home, they have to be paid. And that could be even checking emails. Maybe you have an employee who's hourly, but they check in every night at 8 o'clock just to kind of check their emails, see what's going on. They have to be paid for that time. And they need to know that they have to log that time and let you know that they worked. Now, you can have policies in place that hourly staff members are not allowed to work at home. And they need to understand that that is something that they need to be responsible for, not doing that or logging time if they have worked. But again, if you know they're working, you have to pay them for it. If your supervisors are seeing emails come through at 9 o'clock at night, that needs to set off kind of an alarm in their mind that they need to make sure that employee is clocking in during that time. And then when it comes to travel, non-exempt staff members have to be paid for travel time for work-related duties. So anything beyond their normal commute, they would need to be paid for. So if they come in, they clock in, and then they drive to another office within your conference, that travel time, that driving time is covered. If they leave their home and they have to drive to another office, you pay them for that time beyond their normal commute. So if their normal commute is 30 minutes, but they're driving to an office that's an hour away directly from home, you would pay them for 30 minutes of that time. So just some things to consider. And again, when you're looking at your policies that are in place, these are some things that you're going to want to have. So for non-exempt employees, they have to be paid overtime for any time worked over 40 hours in a week. So your work week should be designated in terms of your policies, in terms of your timekeeping system, whether it's Monday through Sunday, whether it's Sunday through Saturday. You have to have a designated work week. You can't change it based on an employee schedule. Every week you should say, okay, your hours worked are from Monday to Sunday. If an employee works 40 or more hours within that work week, you have to pay them time and a half for any hours worked over 40. So you don't need to say, well, if you work later than 5 o'clock, then you would get time and a half. It's not on a daily basis. Now I say that California has different laws. I'm not talking about California. In general, when it comes to the FLSA, federal law, if an employee works over 40 hours in work week, that's when they get overtime. It's not on a daily basis. You can't say, hey, you worked 48 hours this week, so I'm going to give you a day off next week and it'll balance out. That is prohibited. It's illegal. You have to make sure that you are paying them overtime during the work week for any hours worked over 40 hours. Now, vacation, sick hours, holiday pay, that does not count. I'm strictly talking about hours that they are working, regular work hours. So if you have someone who works 40 hours and then you give them 8 hours of holiday pay, you don't have to pay them overtime for the holiday pay. You're just looking at the hours worked. And again, it has to be 1.5 times their normal rate of pay if you pay them overtime for that week. Now, that being said, we are all budget-based. We are nonprofits. So you have probably, your set budgets for individuals. So you can have policies in place where an individual has to get approval to work overtime, and it has to be approved in advance by the supervisor. And then you can say, yes, you can work overtime because we have it budgeted for this week, or it's annual conference season, or we have something going on. We knew this would happen. You can have that policy in place. And then if an individual works overtime that's not previously approved, you still have to pay them that overtime. You can't say, well, that wasn't approved, so you don't get overtime for that. You can't do that. You have to pay them appropriately for all time that they work. But what you can do is say, hey, as a reminder, here's the policy. You have to get prior approval to work overtime. You didn't. So this is your verbal warning. If you do it again, it could result in further disciplinary action. Just make sure you're getting prior approval. And you also want to say, while you're having that conversation, also know working off the clock is prohibited. So you can't work approved over or unapproved overtime, and you can't work off the clock. The best thing you can do is document that you have these processes in place, that you're following your rules, and you're reminding employees of the requirements as it relates to their role. So you're going to want to watch for things like employees working off the clock, because again, if you're aware that they're working, if you know it's happening, you have to pay them. You're going to have dedicated employees who just want to, out of the goodness of their heart, give you their time and not be paid for it, and they cannot do that. That is prohibited, and that if that keeps being a problem, it has to be addressed. And you have to do it through a disciplinary action, because you cannot be the employer that said, well, I knew that they were working, but I didn't pay them for it because they didn't want me to. As an employer, you cannot do that. You may have employees who are, having performance issues, and they are working off the clock to try to get all of their work done. You need to be aware if that's happening, you have to take care of that and address it. And again, if they're having any sort of performance review issues, or if they're just not getting things done in their normal work week, then you may have to just keep an eye out for that and train managers on what they need to look for. So again, the Fair Labor Standards Act does not require meal breaks, but your state might. So I do encourage you, if you have not already looked into it, to make sure your state doesn't have state laws in terms of if a hourly staff member works a certain amount of time, they have to have an unpaid meal break. If you do offer unpaid meal breaks and an employee clocks out for lunch, you've got to make sure that they're not working during that time. They can't just clock out for lunch, sit at their desk and work on emails or work on projects. If they are clocked out and they're off the clock, they do not need to be working at all. And if they are called back into work, or they get a call they need to take, they need to know that they need to clock in, or let you know that they started working at that time. So as an employer, as a supervisor, it's important that you make sure that all compensable time is accurately reported, whether it be the employee writes down on a timesheet, which is not a best practice, but I know some organizations have to do this. The employees need to write down their start time, when they clock out for lunch, when they clock back in, and the time out that they're out for the day. Employees should be writing down, I worked 7 hours, I worked 8 hours. They need to say, I started working at 8:05. I clocked out for lunch at 12:03, and then I came back at 1 o'clock and I finished the day at 5:17. They need to be documenting the times that they're working so that you can make sure that they're paid accurately, and they need to understand that they are responsible for reporting all of their time. And then you need to make sure you're paying overtime and documenting overtime appropriately. And so as an employer, you need to understand what roles are exempt and non-exempt. So if you have an employee who's working a lot of overtime, you can't just say, man, you work a lot of overtime, or, oh, you have to travel for work, so I'm going to make your job salaried. You can't do that. You have to look at the duties of the job. And there are specific categories in this law where you say this job falls under this exemption. They have direct reports. They make a lot of decisions that relate to the organization. So this is qualified to be an exempt position. If you have someone who's just doing clerical duties, a lot of processing, that would probably be an hourly position. A lot of administrative assistant positions are hourly positions because they're doing a lot of things like checking calendars and scheduling meetings. So those are typically hourly, but you have to look at each job on an individual basis to determine if that job should be hourly or salaried, and then go ahead and move forward with categorizing the job in that way. And you have to make sure that no improper pay deductions are made from exempt employee pay. So we've talked a lot about hourly staff members and how they have to be paid overtime. When it comes to exempt staff members, they do not have to be paid overtime because they're considered exempt. They're given their weekly salary no matter what. They work more hours or less hours, it all works out. Now, you can say if you take a full day away, then you'll use vacation time, or if you take a full day away because you're out on leave, you may be unpaid if you don't have paid time. You can make those types of deductions. What you can't do is say, okay, exempt staff member, you left an hour early today, so I'm going to take an hour away from your pay, or I'm going to require you to use an hour of vacation. They're exempt. They don't get the benefit of overtime. What they get is the benefit of a little bit more flexibility in terms of how they work. So in terms of your policy, I would recommend you say that exempt staff members, maybe take their PTO in whole day increments. If they work 6 hours, they get paid for a whole day because they're exempt. And next week, they'll probably work 8 or 9 hours in a day. It's all going to balance out. As long as they're getting their work done, then they determine essentially how many hours they work in a day. Now, you can have core office hours. Hey, you need to be here at least by 9. You need to stay till 4. This is our work day on a day-to-day basis, and you need to be in the office. But what you don't need to do is be monitoring them or treating them like an hourly employee, because if you do that, you lose the risk of losing that exemption for that position. And then if you lose the exemption under the Fair Labor Standards Act, the Department of Labor is going to say, okay, this employee will now estimate how much overtime they've worked for the past 2 to 3 years, and you will need to cut a check for that amount. So you're going to want to make sure you're treating your hourly staff members appropriately and your exempt staff members appropriately in terms of how they document their time. And you need to make sure, again, if your non-exempt staff members are on a lunch break, that they are actually clocked out and not working. So when it comes to approving employee time cards for hourly staff members, I will say you need to make sure the supervisor is the one approving that time, because they're going to be familiar with what the employee worked. They're going to be able to say yes or no. Notice if any time off is missing. That is just a best practice that the supervisor approves time cards on a, whether it's on a pay period basis or a weekly basis, whatever your process is. They need to make sure that employees are not working from home. And if you have an employee who has an error on their time card, you need to have a process where they can update that and give you that information. So maybe they forgot to clock in for the day. If you have a time punch system, you need a process where they can say, hey, I forgot to clock in. I clocked in at 8 o'clock. Here's my time. where the employer or the manager is not going in and just guessing. You need a process in place where the employee says, here's what my time should be. I need a correction, or, you know, I clocked out for the day at 5, but someone came in my office, they ended up working till 5:45. So can you edit my time? You need to have a process in place, whether it's a form or something like that, or something electronic where they can document any changes. Because what you don't want is for it to appear that the manager is just making changes to the time card without the employee asking them to. So when it comes to the employees, so I would recommend training for managers in terms of what they're responsible for, but also a communication to employees to let them know what their responsibilities are too. They are responsible for documenting their time worked. They are responsible for notifying their supervisor if their time is incorrect. They are responsible for not working from home. They are responsible for getting approval in advance for overtime, things of that nature. So definitely as much documentation as you can do in terms of showing that you're complying with this law, the better. And so also employees should not clock in and out for one another. This could be a problem too if someone's running late. And this is more of, you know, in different environments where there's a strict attendance policy, or, you know, maybe a manufacturing environment, something like that, where someone's running late, they don't want to get in trouble, so they have someone clock in for them. You just want to have a rule in place, or a policy in place that employees must document their own time. They can't clock in and out for one another, and they can't falsify their time cards, because it's not to say that doesn't happen. It can happen, but you definitely want to say that these are the rules so that employees know what's expected of them. And then you need to have a process, again, if they have a pay related concern, they need to know who to go to, whether it's their supervisor or someone in the finance department. You know, maybe they forgot to put in PTO and they didn't get 4 hours of pay, or maybe they forgot to clock back in from lunch, so it looks like they worked a half day when they didn't. Again, have a process in place where they can report pay related concerns. And so I've said all this to say, why is the Fair Labor Standards Act important? Well, you want to make sure your employees are paid fairly. We want to make sure that employees do receive the appropriate pay for all the time that they work, and it just strictly out of being a good employer and making sure that employees get what they are entitled to. But also from a legal standpoint and from the Department of Labor standpoint, these types of charges, if you are violating this law and not paying employees appropriately, these can be very, very costly lawsuits if they are brought against you. So there could be collective actions. There could be individuals who say, hey, I haven't been getting overtime. And then their coworker says, I haven't either. And they come together, they get other individuals, and it could result in a collective action lawsuit. Just some examples here. In the fiscal year 2018, the Department of Labor recovered $304 million for wages that are owed workers, which is great for the employees who weren't getting paid appropriately, but the employers, again, have to pay quite a bit because they weren't following these rules. And then in the past 5 years, they've recovered $1.3 billion. So if you are not following these rules, you're paying an employee inappropriately, it could result in up to 3 years of back pay if you're willfully saying, I know you're a non-exempt employee, but I am just not going to pay you for overtime. So if you work overtime, don't put it on your time card. The Department of Labor can say, well, now the employee can estimate how much overtime they worked the past 3 years, and then you will write them a check for that amount. Suits can be brought by the employees or the Department of Labor if the employee goes to the Department of Labor and they file a charge on the employee's behalf. And then if they do bring forward a lawsuit, the employer has the burden of proving the employee didn't work. And it's really hard to prove that someone wasn't working, especially in the email days and when employees have different applications that they can use. It would be hard for you to say, I know for certain this employee did not work after 5 o'clock last Tuesday, because there are lots of things that they could be doing that you may not know of. So it's important that you are documenting your processes. Your managers are trained on what to look for, and they know what to do, because again, the burden of proof would be on you. And if the employee says, I've worked 4 hours of overtime every day for the past 3 years, and you can't prove they didn't, you may have to write a check for that amount. So you just want to be sure that you are being fair to your employees. So our next section relates to harassment and retaliation. And again, if you have questions, feel free to put those in the chat. We'll get to those at the end of the training, and we'll go through those as well. So harassment relates to any illegal discrimination, which could be employment decisions or any other actions that are taken as it relates to a protected class or protected category under federal law. And so these actions may interfere with the equal employment opportunities that are afforded to employees. So protected categories could be any of those that we talked about earlier: age, race, ethnic origin, color, religion, citizenship status, sex. And so there have been recent Supreme Court rulings that say that sex discrimination could include discrimination based on gender, sexual orientation, gender identity, or pregnancy. Genetic information is also covered. GINA is a law that's in place to protect individuals from discrimination based on their genetic information. So maybe an employee has found out that they are genetically predisposed to have breast cancer, and someone finds out about that, and then they're terminated for fear of, they may need to, take leave in the future. It sounds like a terrible thing to do, but if that happens, GINA is in place to protect that individual from that type of discrimination. And then veteran status and disability are also protected categories. And so harassment could be anything from taking any tangible employment action based on the individual's protected status, or it could be things like making statements, saying stray remarks about the individual's protected status, any sort of behavior from coworkers or supervisors or anything of that nature. So a lot of times when you think of harassment, you think of sexual harassment. That is a type of harassment that could take place in the workplace. And so that relates to taking an employment action based on an agreement or refusal to engage in sexual activity, dating, things like that. It could involve a threat or a promise of a benefit linked to this activity. So if a manager says, hey, I can give you a promotion if you'll go on a date with me, I'll give you this for that. And that's where that quid pro quo comes in. Or it could not be an overt proposition. It could just be that the manager maybe keeps asking the employee to go out, or they make statements that could be perceived as inappropriate or sexual in nature. So one thing about sexual harassment that's very important is that your managers cannot engage in that activity. And you as an employer could be liable if they do that. So you're going to want to make sure that your managers are trained in extensive sexual harassment or harassment as it relates to those protected activities training, so that they know what not to do. They know what types of behaviors are inappropriate, but they also know what to look for. They know that if their employee comes to them and says, Bob keeps asking me on a date, I keep saying no, he keeps asking, they know who to go to investigate that issue. They know that they have a responsibility to take some sort of action. They can't just laugh it off and say, well, that's Bob, and go about their day. So I do recommend that you get some sort of sexual harassment training for your managers, just so they know what's appropriate and what's not. And then definitely want to train all of your staff members on what to do and what not to do in the workplace. And so any sort of harassment is any unwelcome conduct that's based on someone's membership of one of those protected activities that could interfere with their job performance, or it creates an intimidating or hostile or offensive work environment. So when we choose the term hostile work environment, a lot of people think that just means that, you have a disagreement with another employee, or they're being mean to you essentially, or you don't like how someone's behaving. But a hostile work environment is a legal term that relates to an individual's conduct as it relates to one of these protected classes. So if someone comes to you and uses that term, you as the employer needs to know what to do with that information and how that information is investigated and what to do and what your next steps are. So harassment, again, is prohibited. That includes anyone who is in your organization or comes to your organization. So it could be employees, but it could also be customers, it could be vendors, it could be visitors, it could be individuals that person comes into contact with every day in the workplace or any days in the workplace. So if you become aware that maybe you're a delivery person who comes in every day is saying inappropriate things to your employee, you are responsible for making sure that stops and protecting that employee from that type of behavior. And so employees, again, should feel comfortable in reporting these concerns. They should know who to go to. They should know what will happen if they do report that information. Because again, they should feel comfortable coming to you and not feel like, well, it's the delivery person. He makes these comments that make me uncomfortable, but I don't want to get in trouble for saying, that this delivery person's doing this. You need to make sure they understand that they are protected and they need to come to you if they feel uncomfortable. So again, I mentioned training. I definitely recommend that you have a training for your supervisors and for your staff members on what to do, what's appropriate and what's not. But it's very important to have policies in place too, documented policies. So an employee can say, I feel uncomfortable. I'm going to go to my policy manual and here is what I need to do. Here is what's prohibited and here is how I need to report something if something is happening to me. So you definitely want to make sure that you have a policy in place. Part of that policy is that managers understand that they have a responsibility to take action if they become aware of harassment. And if they become aware of any sort of inappropriate activity in the workplace. So that being said, if they oversee someone who, they see them behaving inappropriately, or they see them talking to an employee a certain way, or someone speaking to their employee a certain way, they need to know they can't just ignore it. As a manager, you have a responsibility to go to someone within the organization who knows how to handle this sort of situation and what they need to do. If an employee reports the information to a supervisor that they feel like they're being harassed, that is considered reporting under the eyes of the EEOC, and you have to take action. So the manager needs to know if an employee comes to them and says, please don't tell anyone, but Bob will not stop asking me on a date and I don't know what to do. They can't just say, well, I won't tell anyone. I know you told me and I really wish I could help you, but you said not to tell. As a manager, they have a responsibility to report that information. So when an individual comes to them or comes to human resources and says, I want to report something, they need to understand that you can't just say, don't tell anyone, and that's the end of it. There are certain things that employees report that you have to take action on. And you can say, if you let me know, I understand you're coming to me and you want me to keep this confidential, but you need to know if you tell me something I have to investigate, I'm going to keep it as confidential as possible, but I do have to conduct an investigation, or I do have to look into your concerns. I cannot just ignore this information. I have to take next steps. So they need to understand that you will be making a good faith effort to do an investigation into their concerns. And again, I use the term as confidential as possible, because if Joe keeps asking out this employee, you're going to have to go to Joe and say, Joe, have you been asking out this employee, or have you been asking out any employees? And if Joe knows he's been asking Susan out every single day, he's going to know Susan complained. So you can't say, I will keep this absolutely confidential, because you have to follow a process to investigate these types of claims. And someone may figure out that someone reported a concern. But what you need to do is have a process by which you investigate these claims, have someone in your organization who is trained on what to do if these claims come to you, and then have a policy in place that prohibits retaliation. We'll talk about retaliation later on. But they need to understand that if an employee comes to you, you will do a good faith investigation, and that you will follow and take prompt and appropriate action. So the EEOC actually has a process you have to follow when you have a sexual harassment or harassment concern. There are steps that you have to follow to do the good faith investigation. And the end result of that is that you go back to the complaining employee and you say, we've completed our investigation. The appropriate action has been taken. Or you say, we were not able to substantiate your claims. We have looked into it, and we were not able to substantiate the concerns that you have. The EEOC actually requires that you follow this process. So it's not like you're being extra protective, or you're taking these extra steps. These are required by law to protect employees, and so that they know that they can report these concerns and they'll be taken seriously. So what you don't want to do is go back to the employee and say, Susan, we've looked into your concerns and we have terminated Joe. You don't want to tell the employee what happens at the end, because that is considered, confidential in terms of what employment action is taken on the other employee. But you can say, the appropriate action has been taken, and then your investigation is complete. So again, it's a pretty thorough process. I definitely recommend that you have someone trained within your organization on how to handle those types of claims. But also, it wouldn't be a bad idea to have someone who is a member of one of your local human resources Organizations, the Society of Human Resources Management, they have a national organization or local organizations that you can join. And then you can go to trainings for either free or for a small fee that cover the types of behaviors that are prohibited or any updates to legal employment laws, things like that, so that you have someone who's well versed on what to do and knows how to handle these situations. And you're going to want to have a zero tolerance policy when it comes to retaliation. So again, we'll talk about retaliation in just a moment, but you want to make sure that your policy covers all of these bases so that it says employees can report these concerns, what you will do when they do, and that they'll be protected if they made a good faith report of what happened to them. So again, your managers must act if someone comes to them, and that's anyone. It could be someone that they don't supervise. If anyone comes to them and says that they have a report of harassment or a concern, they need to know that they need to take action. And again, even if they don't explicitly say, I need your help, I feel like this is happening, or please, take action or investigate this. They don't have to explicitly say that. If they just mention, Joe just will not stop asking me on dates, that's enough to trigger a manager to know, I need to do something. I need to tell someone in HR or tell a designated person who can investigate this. So when it comes to retaliation, the equal employment law requires that there is no action taken or no punishment for an employee who reports a concern. That could be discrimination or harassment. And it's not just, I reported my manager for harassing me. He kept asking me on a date and I reported it. Well, he didn't get fired, but now he treats me differently, or now he terminated me because I made this report. It's not just, terminations. It's not something as straightforward as that. It's treating that employee differently in any way because they brought forward a concern. So what you want to do is have a policy of anti-retaliation. So it is unlawful to treat an employee differently or retaliate if they communicate to their manager that they feel like they've been harassed, if they have been questioned as part of an investigation. Maybe they were named as a witness in an investigation into harassment and they answered honestly and they were called in, and then they start being treated differently. That's prohibited. You can't retaliate against employees. If they refuse to follow orders that could result in discrimination, if they refuse to follow orders that are against, your policies that you have in place, resisting sexual advances, or if they intervene to protect others if they see something happening, or requesting an accommodation of a disability, or asking managers or coworkers about salary information if they're looking for discriminatory practices. So asking these questions, being involved in these investigations, this is all protected in terms of retaliation. So you cannot treat employees differently. You cannot demote them. You cannot keep them from training opportunities. You can't transfer them. You can't change their work schedule, to be different unless it's for a business reason, obviously. But if if they've been coming in at 9 to 4 and suddenly you feel like they should come in at 7, that can be perceived as retaliation. So just keep in mind the employee's perception is part of this retaliation law, and you just need to be consistent in the way that you behave towards employees, especially if they've brought to you a concern. But again, a manager treating them differently, or maybe the manager stops speaking to them in the mornings. You need to have a policy in place that 1, prohibits retaliation, but 2, gives the managers examples of what could be perceived as retaliation, so they know how they need to behave if an employee brings forward a concern. So again, if they're reprimanded, that could be perceived as retaliation. Again, if they're transferred, if there's any sort of verbal or physical abuse, that's pretty straightforward. That could be perceived as retaliation. Maybe that employee's been about 5 minutes late a few times a week for the past few months, and the manager's never mentioned it. But now that employee's made a complaint against the manager, and the manager starts writing them up for being 5 minutes late. If you increase your scrutiny on the employee, or things that didn't matter before start to matter now, that could be perceived as retaliation. Spreading false rumors is an example. Treating a family member negatively. If the employee's spouse or works for the organization and they start being treated differently, that can be perceived as retaliation for an individual engaging in a protected activity. or making their work just in general more difficult. So changing their work schedule, changing their work duties when there's not a business reason after they filed a complaint. So again, retaliation, you have to have a zero tolerance policy. But one thing I do want to point out is that retaliation claims, and I've pulled up here the EEOC fiscal year 2020 statistics. These are all of the charges that were filed through the EEOC for these federal laws. 55% of them were retaliation claims. So retaliation is preventable, but it is the most common claim that individuals go to the EEOC with. If they've made a complaint and they're treated differently, or if something happens after they've made a complaint, then they can file a retaliation claim with the EEOC. And different states have different laws, but essentially they have anywhere from 180 to 360 days to file a claim after something's happened. So if they file, maybe they file a complaint, they participate in an investigation and they get terminated 3 months later, they have 180 or 360 days from that date of termination to go to the EEOC and file a complaint. And I've also got this in chart form, so you can kind of see retaliation was the most common claim, disability was the second, pretty close to race, and then sex, age, national origin, all the way down to genetic information. That is the lowest number of charges that were filed, probably because not a lot of people know that that's a law. And employers have practices in place where they don't get that genetic information, so that helps too. But just some things to consider. And again, the EEOC oversees you as an employer. So your employees can go, even though we're a religious organization, they're still considered employees in terms of the EEOC. So they could go and file any of these claims if they feel like they've been discriminated against, harassed, or anything of that nature. I do want to briefly talk about the I-9 form and E-Verify simply from a process perspective, and then also as it relates to discrimination. But I'm going to briefly talk about Form I-9 and E-Verify, but when Andrew sends out the email after this training, we have a very extensive I-9 training that talks you through the form and how touchy the form can be and the things that you need to consider. So again, I'm going to go very high level over it right now, but if you want more information about the I-9 form, Andrew will send you that training after this. So each of your employees should have an I-9 on file. The I-9 determines an individual's authorization to work in the United States legally for an employer. That form there are a lot of rules around the I-9 form and a lot of things that have to be done for it. But one of the things that you need to note as an employer is you cannot complete an I-9 form for someone before you've made an offer of employment, because that could be perceived as you're trying to get information about their citizenship status, national origin, things like that. So your I-9 has to be completed after the offer of employment, after your signed offer letter is completed, and then on or before the first day of employment. Now, that being said, I-9 has two sections. Section 1 is completed by the employee, and Section 2 is completed by the employer to verify the documents that they provide to you. So Section 1 has to be completed on the employee's first day of work. Section 3, you can complete up to 3 work days later. Or sorry, Section 2, you can complete up to 3 work days later. If you have incomplete or missing forms for your employees, the fines from ICE for them finding these forms and these issues could be anywhere from $100 to $1,100 per violation or per form. So you could have an audit where the ICE individuals come in and say, we want to review your I-9 forms. And again, they can find you up to $1,000 per form, especially if they're missing documentation, if you're missing forms, things like that. You have to retain your I-9 forms for your terminated employees, and ICE can review those as well. So what you'll want to do is keep all of your I-9 forms for active employees together. You don't want to put those in the employee files because you don't want to have to dig through all the employee files to find all your I-9s if you are selected for an audit. So you want to have all of your I-9s together for active employees, and you're going to want to keep all your terminated employees' I-9s together as well. You have to keep that form either 1 year after the employee's date of termination or 3 years from date of hire, whichever is later. So if someone leaves, they work for 4 years and they leave, then you would have to keep the form for 1 year after their date of termination. If someone works for you for 6 months, you have to keep that form for 3 years from their date of hire, and you have to keep it in a file. And again, you have to produce it for an audit. So just some things to consider in terms of how you keep that form. So this form is updated fairly frequently. So you want to make sure, first of all, for your new hires, you're using the most recent version of the form. Employees will complete section 1. And you can tell which version of the form you have because of the expiration date that's at the top right corner of the form. But again, the employee completes section 1. They would check if they are a citizen, a non-citizen, lawful permanent resident, or an alien authorized to work, and they would fill in that information and sign and date the form. Again, this has to be completed at least by their first day of employment. If they complete it after the offer letter, but before the first day of employment, that's fine too. But again, by the first day of employment, by the end of that day. If you need to have someone prepare or translate for them, then there's a section for the preparer or translator to fill in their information. If you don't have a preparer or translator, then they would just check that they did not need one, and you would leave the section blank. Section 2 is completed by the employer. So again, you're going to kind of have them complete it after the offer letter so that you're not perceived as doing anything discriminatory. But when it comes to these documents, you cannot tell an employee what to bring in. You can't say, I need your driver's license and social security card. You can't do that. I know that previously in years past, you've seen individuals who say that you need a social security card to come work, bring that on your first day. That is prohibited. You cannot do that. What you can do is give them a list that comes with the I-9 form that has the documents that can be used for the employer to complete this section of the form. And they will either bring in one form from List A, and List A documents cover both bases. They identify the employee and they show that they're authorized to work in the US. So it's something like a US passport, not a passport from another country, a US passport. That is a List A document that would suffice. So you give them the list of documents and they bring in one document from List A or a document from List B combined with a document from List C. List B documents just identify the employee, and List C documents show their authorization to work in the US. And then you, as the employer, would review the documents. You cannot look at copies. That's prohibited. You are attesting when you sign this form that you are seeing the original document. Now, there are provisions if they don't have their social security card, but they go and get a receipt, you can use a receipt for the first 90 days of their employment. We're also going to send you the link to the I-9 handbook that the USCIS releases, and it has very specific information about how you complete this form. If you have any questions, it's a great tool to have if you have any questions about how to complete this section or the form in general. So they bring you their documents, they have looked at the list, they bring you their driver's license and their birth certificate. Okay, that works. Or their driver's license and their social security card. So you would take the forms and you would complete this section. You would enter their information in the employee info from section 1, and then you would put the document information on List B or List C. You want to make sure you're filling out the appropriate section. And then you would sign the bottom of the form attesting you as the employer reviewed the documentation. So again, the employee must complete section 1 on the first day, and then you have 3 business days to complete section 2. So if they start on a Monday, you have until end of day on Thursday to complete section 2 for the employer. If they don't bring you those documents, technically you should tell them they cannot work until they bring it in. They have to show they're authorized to work in order for you to complete that form. Then when you complete the form, always make sure that you're completing it accurately. Don't backdate the form. Don't use whiteout on the form. Complete it accurately. And then if they bring in more documents, let's say they decide to bring in their passport along with their driver's license and their social security card, don't put down more documentation than is required. You can say, okay, this is a List A document. I just need this. I'm going to give these others back to you. And you only put the List A document on the form. So again, if they bring in more on their own, just don't put it on the form. And then if you decide to make copies of the forms, you can make copies of the forms that they bring you, and you can put that in the file as well, but you'll want to do that for all employees or none of the employees unless it's required by your state. And then you would sign the form listing the employee's first day of employment and then your information and the organization's information. You may be required, depending on where you work, to use E-Verify. So that is an online system that verifies an individual's ability to work in the US. So if you are required by your state to enroll in E-Verify, then you should do so. If you're not required, you can still enroll in E-Verify and use that system just as a good faith effort to verify employment status. But that's just something to note. I would look into that depending on the state that you were in. It's based on state and again, number of employees. So if you are required to enroll in E-Verify, then you would definitely need to do that.